Okay, I think we've got a few more folks that might be joining us a few minutes late, but I'm going to get started right away. So welcome. My name is Charlotte Robinson, and I'm the president of the Thunder Bay Chamber of Commerce, and we're thrilled to have you here today for this session. We'll start with the acknowledgement that the City of Thunder Bay is built on the traditional lands of the Ojibwa peoples of the Fort William First Nation, original signatories to the Robinson Superior Treaty, which was signed in 1850. And we recognize the significant contributions of the First Nations, Inuit, and Métis peoples to our heritage, social, cultural, spiritual, and economic wealth. In recent weeks, the Chamber has received numerous questions from employers about vaccination policies for the workplace, which is why I'm so pleased to welcome today's speaker, Warren Mouck, to help provide some guidance and hopefully clarity on this complex issue. So Warren is a labor and employment lawyer with O Neill Associates, human resource, labor, and employment lawyers in Thunder Bay. And he provides advice and representation to individuals and businesses on all areas of workplace law, including employment standards, occupational health, and safety matters, as well as human resource management. His presentation today will focus on what small businesses need to know about vaccination policies and their obligations to employees regarding protection from COVID-19. Over to you, Warren.
Thanks very much, Charlotte, and thanks for the opportunity to participate. I always enjoy working with the Chamber on these types of events, so it's much appreciated. In terms of my presentation, I'm also happy to field questions afterwards, and I'm hoping there will be a Q&A because that's always more valuable in my opinion. But I'm happy to field questions that are outside the scope of COVID-19 and within the scope of employment law if it happens to get there. I know we had a good chat just now about the increase in the minimum wage. Any questions like that or any other questions, happy to talk about them. So the first thing I'll do is go through my brief PowerPoint presentation, and then I'll open up to a Q&A after that. So I've got it. Workplace vaccination policies for small business. And when I talk about policies, that can sound a little bit daunting because you get the sense or get the image in your head that you have to have like a large binder of very comprehensive policies. And that's just not the case. The more organized employers are with their policies, the better. But when it comes to having policies, it's simply a matter of having some sort of written statement about your ability to comply with the law and your intention to comply with the law. The benefit of having workplace policies is you can say something as simple as, we're going to follow the legislation. And then if you get questioned about your policies, from Employment Standards, Ministry of Labor, anyone else, you have a source document that you go to. And the beauty is when you have policies, you're applying it equally to everyone, because one of the areas that employers can get in trouble with is not applying their workplace policies equally. That's a big source of contention. What I'm going to do is, for the sake of simplicity, talk about the legislation governing the status of workplace vaccination policies right now. And the biggest question a lot of people are going to have is, do I have to have a workplace vaccination policy? Do I have to make vaccination mandatory in my workplace? Can I fire someone if they don't comply with my policy, if they're not vaccinated? What about the human rights aspect of it? Lots of confusing information out there, so I'm going to try and distill that down. Starting point on this presentation is going to be the Occupational Health and Safety Act. That is for provincially regulated employers. And you saw my disclaimer at the beginning of the presentation that this is legal information, not legal advice. Provincially regulated employers are the majority of small businesses in the province of Ontario. They're subject to the Employment Standards Act, which is provincial legislation, Occupational Health and Safety Act, also provincial legislation. Federally, you're looking at like airlines, telecom companies, banks. We're not talking about that today. Those entities are subject to the Canada Labor Code, and they're usually the larger employers. If you're a federally regulated entity or a business, just bear in mind that you want to look at the federal legislation, not the provincial legislation. It'll generally speaking be one or the other. And more often than not, the policies and the principles are pretty similar in the OHSA from the provincial to the federal legislation. So the provincial legislation has this catch-all provision that requires employers to take every precaution reasonable in the circumstances for the protection of a worker. And I've had this discussion with a number of my colleagues about whether that requires mandatory vaccination. And it doesn't. The Occupational Health and Safety Act doesn't require vaccination policies, or it doesn't require employees that are working in the province of Ontario to be vaccinated. What it says is, if there's a precaution that you can take as an employer that's reasonable for the protection of a worker, then you should take that precaution. I don't think this is going to translate into the Ministry of Labor coming into anyone's business and saying, is everyone here vaccinated? Do you have a mandatory vaccination policy? That's just not the case. You have to look at the individual circumstances of your place of employment and decide, based on everything that we do as a business, is it reasonable and necessary for the protection of workers for me to have a vaccination policy? If you think it is, then you might want to talk about mandatory vaccinations. The one issue that comes up, and I found very interesting, is the science behind it, which is constantly evolving. And this whole area of law is constantly evolving. But the question becomes, okay, if I'm not vaccinated, there's not enough data to say that vaccination necessarily prevents the spread. If I'm not vaccinated, that's my individual choice, right? And if other people are vaccinated, I'm not, well, those people are protected. Maybe I'm not. What the legislation says, it's a bit paternalistic. As an employer, if you're telling employees you need to be vaccinated to work here, you're basically telling them that they need to protect themselves. So it's paternalistic in the sense of, just like you require individuals to wear a seatbelt in a car, that legislation is in place to protect you, something that you need to do to protect yourself. So employers also have to do that. If you think about people who work at heights, employers require them to have fall arrest equipment, so there's no danger of falling. Lots of things employers do are simply to protect the individual worker from ways that they may injure themselves. So arguably, this section of the OHSA, in many circumstances, if you think it's a reasonable precaution to require people to get vaccines, you're doing so simply so they protect themselves. There's a lot of debate that the legislation itself doesn't require it, just to be clear. But if you're looking for a justification, if you want to have a mandatory vaccination policy in your workplace, you've decided that's something you want to do, that's your rationale. I'm protecting you by forcing you to get vaccinated or requiring you to get vaccinated. Of course, you can't force employees to get vaccinated. So that's the underlying legislation in terms of health and safety. I think it's very important to keep in mind the legislation does not require you to make vaccinations mandatory for your workforce. It does require you to give consideration to it. Do vaccines need to be mandatory in my business? So that's kind of the starting point, very gray area. The other thing is human rights. This comes up quite frequently. People say, well, mandatory vaccination is against my human rights. When you're talking about human rights in the employment context of the province of Ontario, human rights has a very specific meaning. And that meaning is you will not be treated adversely or in a negative way because of any of these listed grounds: ancestry, place of origin, color, ethnic origin, citizenship, creed, et cetera, et cetera. These are what are called immutable characteristics. You can't discriminate against people because of things about themselves they can't change. So when you talk about the need to accommodate someone with a disability, in this case, the most common exemption to the requirement to get a vaccine is going to be a medical exemption. And arguably, it's the only exemption. The basis of disability, I can't take the vaccine because I have some reaction that's dangerous to me, or it causes me to be unduly sick or whatever. That is a medical exemption to the requirement of a vaccination policy. So if you're imposing a vaccination policy, requiring employees to show up and be vaccinated, be mindful that some individuals have a legitimate reason for not getting the vaccine, and it's usually on the basis of a medical reason. And if there's a valid, bona fide medical reason, then that person should be exempted. And to dismiss that person from their employment for not getting the vaccine when they can't get the vaccine because they have a medical reason, you run the risk of contravening the Human Rights Code, that's discrimination. There's monetary damages associated with that, way down the road if it gets there. So that's something to be mindful of. The other one that's come up, I've had dealings with people who raise religious or creed-based objections, and in some cases, in many cases, they're honestly held objections. I believe in my heart of hearts that my religion prevents me from accepting this vaccine. That may be the case. What that's going to come down to is basically a balancing of, is it important enough that we have everyone vaccinated versus protecting that person's religious rights and freedoms? I think the way things are going, it's very unlikely that someone who raises an objection that the mandatory vaccine policy offends their religious freedom, I think it's very unlikely that they're going to be successful in proving that that constitutes discrimination. So I think from a legal perspective, what I've seen, and again, this is constantly evolving, the only valid exemptions are going to be a disability-related exemption, medical evidence supporting that I can't get a vaccine. Aside from these protected grounds, that's all human rights means in the employment context. Human rights has different meanings in other contexts. You talk about international law and the right to clean drinking water is sometimes characterized as a human right, for example. That's different. We're talking about provincial employment legislation. Your human rights are what's protected in the Human Rights Code, and it's limited to these factors. So that's very important. The other issue is, assuming that there's no human rights issues involved, if someone refuses to get the vaccine and you have a mandatory vaccine policy and they have no valid exemption, am I allowed to dismiss an employee for failing to comply with my vaccination policy? The answer, generally speaking, again, subject to the Human Rights Code, is yes, you are. You're permitted to dismiss a non-union employee at any point in time, provided you give that individual termination and severance pay. So the answer is there's a cost associated, or a potential cost associated with dismissing that employee. There is debate because there's no case law that's come out yet, so no decisions of the courts yet that I've seen about whether an employer will have just cause to fire an employee. Meaning, I don't have to pay you termination and severance pay because you lost your job as a result of your own misconduct, right? Employers may have just cause to fire an employee if that employee is stealing, if they engage in some other criminal behavior in the workplace. That's when you're likely going to see just cause. There's a legal definition of what constitutes just cause in the Employment Standards Act. And that is, an employer will have just cause to fire an employee if that employee has been guilty of willful misconduct, disobedience, or willful neglect of duty that's not trivial and has not been condoned by the employer. If you have a long-standing employee and they're, maybe they're a 20-year employee and their only offense is that they're refusing to get vaccinated contrary to your vaccination policy, it's my opinion that it's very unlikely that you'll be successful in dismissing that employee for cause. And so you may be liable for termination and severance pay. And the longer the employee's been around, typically the more termination and severance pay you're going to be liable for. And there's a number of factors that go into that, but generally speaking, length of service is a big one. There are some other articles that I've read. One was by Howard Levitt. He's a lawyer in Toronto. He seems to feel very strongly that failing to get a vaccine, because of all these benefits and the way things are going, failing to get a vaccine is going to amount to just cause. I think it's too early to tell, and I wouldn't be able to give you a definitive opinion, and I think I'd respectfully disagree with that one. It just seems like if the only offense is not getting a vaccine, that's not going to amount to willful misconduct, disobedience, because it's an individual right. Whether you decide to accept some medical treatment or not, the employer can't force you to do it. All the employer can do is fire you if you don't do it. So that's my comment on whether there's just cause. So long story short, there's risk. If you dismiss an employee for not getting vaccinated, you may be liable for termination and severance pay. This is what I've already said is Charla's area of expertise. The framework for what businesses have to do to comply is in this regulation, OREG 36420. That regulation's been amended many times, but it's a legislative consideration because it sets out, things like capacity limits, which have recently been lifted, and individual compliance with personal protective equipment, masks, etc. So do your own research on that point. That's the regulation that sets out all the specific details of things businesses have to do to comply with COVID protection requirements. The other policy statement, and this kind of restates what I've already said, but policy statements are basically, this is our overarching view of the ability of an employer to impose workplace vaccination policies. So the Ontario government has given a policy statement that businesses and organizations may choose to implement policies that require workers to get vaccinated. So the government is saying, as our policy, they may choose, keyword may, it's up to you as an individual business. There are certain exemptions where it's legislated. Certain healthcare industries, it's a legislative requirement that you take certain precautions. Otherwise, the government's going to leave it to you and leave it to you to figure out, based on that requirement in the Occupational Health and Safety Act, take every reasonable precaution to protect workers. You decide for yourself if implementing a workplace policy that requires vaccination is appropriate. On that issue of human rights, and what I've already said, the Ontario Human Rights Commission is different from the Human Rights Tribunal, but the commission basically interprets and gives policy guidance on how the Human Rights Code will be applied. And what it said is a person who chooses not to be vaccinated based on personal preference doesn't have the right to accommodation under the code, right? So it's saying I strongly believe in the right to be, free from the obligation to be vaccinated. I strongly am against vaccination for whatever reason. The Human Rights Commission, which largely dictates how these cases are going to go if a discrimination complaint is made and has a lot of influence over the way the tribunal interprets the code, they're saying, no, your personal preference is not sufficient. You don't have protection under the Human Rights Code. Medical accommodations, in my opinion, and what the Human Rights Commission appears to be saying, are the sole ground on which people can validly refuse vaccinations and still be entitled to their job if there's a mandatory vaccination policy. So that's important to keep in mind. I've already talked about non-union workplaces. So you can require vaccination policies. There's no reasonableness requirement. It's up to the employer how they want their workplace to run, subject to things like the Human Rights Code. If you want to dismiss an employee for not getting vaccinated because you've got a policy where everybody does, that's your prerogative. You run the risk of being liable for termination and severance pay. Unionized workplaces, for a lot of small businesses, this may not apply, but there is a reasonableness requirement. So unionized workplaces are different, because if the employer is going to impose a policy and it's not already set out in the collective agreement, then there's something called management rights. So in your collective agreement, there's always, or usually always, a management rights clause that says, except for everything else that's in this collective agreement, we have the right to manage the workplace. We're management, we own the business. We're entitled to make decisions, make policies. When it comes to imposing mandatory vaccination policies, assuming there's no collective agreement language that governs that, if the employer is going to unilaterally impose it, there's about 6 categories, and this comes from a Supreme Court of Canada case, 6 categories that you need to check off that before you can validly impose it and not run the risk of a grievance being successful at arbitration. So can't be inconsistent with the collective agreement, must be reasonable, must not be unreasonable. Means it must be, in the circumstances of your workplace, necessary. If I have an employee who's working from home and they've been working from home even before the pandemic and they're in a union, probably not that common, but if they're working from home, why do I need them to get vaccinated? I'm never going to see them, but they're doing their job. Must be clear and unequivocal. We must know exactly what the policy says and what the consequences is. It's got to be brought to the attention of the employees within a reasonable amount of time so they can comply with them. The employee concerned must have been notified that a breach of the policy could result in discharge if you're looking to fire an employee because they haven't complied with the policy. They have to give adequate notice that that's coming into force. And again, this goes back to consistent enforcement. In both unionized and non-union workplaces, it's very important to be consistent in your application of policies. If you give an exemption to one person without, for no good reason, and you don't apply that elsewhere, you can't rely on that, or it's not going to be a successful argument to try and rely on a policy that you haven't applied consistently. So if you're going to impose a policy, make sure it applies to everyone. And again, when you're talking about medical exemptions, the policy still applies to someone who's seeking a medical exemption, but that person then says, no, I can't take the vaccination because of for a valid medical reason. Got a few frequently asked questions, and I hope that there are other questions, and if you have them, please put them in the chat. If I haven't answered them or I haven't answered them well enough, then I will re-answer them. First one, can my employer force me to get the COVID-19 vaccine? No, they can't. Nobody can force you to get the COVID-19 vaccine. Your employer can say, I don't want you to work here anymore if you don't have the vaccine and you don't have a valid reason for not getting it. They can't force you to get it, but your job may depend on it. Can my employer implement mandatory testing for COVID-19? Again, yes, they can, subject to any human rights issues that may arise. Can't really think of one off the top of my head right now, but certainly the employer in a non-unionized context can implement that. And in the union context, they can implement it so long as it is reasonable and it otherwise meets those 6 requirements that I just mentioned. Will employees be forced to pay out of pocket for their testing? This is something that comes up when someone says, okay, I don't want to get vaccinated. The employer says, all right, but you've got to pass a COVID-19 test before every shift. That is, again, workplace specific. If it's reasonable and necessary, that you have a COVID-19 policy and the employee is making the decision to not get the vaccine and don't necessarily have a valid exemption, then I think the employer may be justified in asking that employee to incur the expense. Again, you would need to be well satisfied that it's necessary for them to have that test before each shift or however frequent you want it. And that's going to be based on the prevailing circumstances at the time. How many cases do we have in the community? What's the risk that this employee is going to come in and transmit COVID-19 if they're not tested? And if the risk is high and you can demonstrate that, then by all means, maybe a testing policy is justified. Can employees be disciplined for refusing the vaccine or testing? Again, it depends on union or non-union workplace. Absolutely, you can discipline them for refusing the policy or breaching the policy in the non-union context. If the policy's reasonable, it should be reasonable if you're going to discipline them. Ultimately, discipline is to correct behavior. So when you're disciplining an employee, the presumption is you're disciplining them to fix what they're doing wrong. So you'll often see discipline in the context of poor performance. Discipline in the sense of a vaccine policy is a bit different. You're saying you might give the employee a written warning saying, listen, we implemented a vaccine policy, you didn't do it. And now I'm going to write you up and say that if you still don't get the vaccine or you don't comply with our policy, I'm going to fire you. And so the purpose of discipline in that case is to give the employee another warning that they need to comply with the policy. But yes, they can be disciplined for refusing the vaccine. Again, in the union workplace, they can be disciplined for it, provided the employer is implementing the policy that's reasonable and necessary, and it ticks all those boxes. The consequence for an employer who doesn't comply with the policy obligations in the unionized context is the employee is going to grieve their discipline, whether it's a written warning or a suspension or whether they're fired, and the grievance will be successful, and the arbitrator will overturn either the policy or the discipline that was imposed on the employee. So it's important to bear in mind the unique circumstances of your workplace and what you actually need for health and safety in the workplace. Charter of Rights and Freedoms. This is one that comes up from time to time. Don't I have the right to refuse the COVID-19 vaccine pursuant to the Charter of Rights and Freedoms? The Charter applies to government action. Small businesses, by and large, are not government action. So most small businesses would not be subject to the Charter of Rights and Freedoms. They are subject to the Human Rights Code, which is applicable to all businesses in Ontario. Charter of Rights and Freedoms may be applicable to government institutions, some of the broader public sector. That's a bigger issue, and it's typically not applicable in the small business context. So those are some frequently asked questions. I see someone in the chat. I'll just give a few remarks to conclude on that. Employers are entitled to require vaccinations of their employees in terms of having a policy. You must implement those policies within the confines of employment legislation. So if you're going to say you have to have a vaccine to work here. You need to appreciate that in some circumstances, someone may have a valid medical exemption. If they bring that exemption to you and you fire them, you're probably breaching the Human Rights Code, discrimination on the basis of disability. I always say that, there's a lot of issues with communication that arise when it comes to the vaccines. If you're thinking about discipline and dismissal for non-compliance with the vaccine policy, think twice about that and use that as a remedy of last resort. It's probably more productive to talk to that employee, see what the concerns are, and see if you can talk through a solution that may work for them, right? There's a lot of misunderstandings about what actually may be required or what solutions might be available. Don't jump to the conclusion that if someone's not complying with the vaccine policy that they need to be disciplined or dismissed from their employment, because there are potential legal ramifications, including cost of dismissal. Human Rights Code, people raise that language all the time. What about my human rights? It has a very specific, discrete meaning. You can't treat someone adversely on the basis of a protected ground like their age, sex, gender, all of that. It doesn't protect personal preferences. So if I personally believe that I don't want to get the vaccine, I'm not protected under the Human Rights Code. I need to establish that my employer's requirement to get a vaccine somehow infringes on one of the enumerated grounds. People will raise disability grounds, but that one seems to be valid, provided that the medical evidence in support of it is sound. The other one is, religious or creed-based grounds. Those ones, just from what I'm observing, anecdotally and speaking with other lawyers that are practicing in the area, not going to hold up. So the employer is going to still be entitled to dismiss someone who raises a religious ground, even if it's a bona fide religious ground. That all depends on the circumstances. A year from now, if we're out of the pandemic and it's not an issue and there's no new cases and it appears to have waned, probably a completely different discussion. Maybe if I have a religious exemption at that time or a religious objection at that time, then maybe I've got a valid one, and I don't have to get the vaccine. So all should be looking at the evidence at the time, the circumstances of your individual business, and ensuring that you're making a good faith effort to comply with the applicable legislation. On that good faith effort piece, that means good faith, acting for the legitimate purpose of keeping the workplace safe. Using, ulterior reasons or the requirement to get a vaccine to get rid of a long-standing difficult employee, that's not a good faith reason. You should try and avoid that, because you might run into trouble there. So those are my remarks for right now. I see there's probably some questions coming in the chat. By all means, please put those in there. Charlotte, do you have any comments before I address what's in the chat?
No, that's really great information, Warren. There's a couple of really good questions in the chat, so why don't we just flip over to those?
Sure.
So Amanda's asking, is it reasonable to place an employee on an unpaid leave of absence rather than terminating them without cause for not receiving the vaccine as per a mandatory vaccination policy?
So the Employment Standards Act has an infectious disease emergency leave. I guess one of the issues is the leaves set out in the Employment Standards Act are leaves that employees request. So when you have the ESA, there's probably a dozen different types of leaves that you can take, medical leave, reservist leave, family emergency leave, all these things. Infectious disease emergency leave was a product of the outset of the pandemic. That was what was happening was, I can't come to work. I need a valid leave. I'm not being laid off or fired necessarily. I need that leave. When you talk about placing an employee on a paid leave, there's a presumption that the employee is the one who's accessing the benefit of those leaves that are in the Employment Standards Act. The Employment Standards Act is to protect employees. So the employee is the person, presumably, that is asking to be placed on the leave. If the employee agrees, you have a good relationship with that employee and say, listen, we've got this vaccination policy, then yeah, it is possible to place the employee on an unpaid leave. There's a couple of considerations there. If the employee doesn't agree with it, they're saying, I still want to come to work. And you're saying, well, no, I want to place you on a leave because we have this policy. The employee may come back and say, well, that's a constructive dismissal. You're fundamentally changing the terms of my job by not giving me shifts. You're not giving me hours. You're basically treating my job like it's over. you run the risk of there being a termination or a constructive dismissal claim there. The other issue is there are timelines in the Employment Standards Act for how long an employee can be laid off for. And the whole purpose is we don't want employees to be indefinitely off work until we don't know how long. So when an employer lays off an employee, in certain circumstances, that becomes a deemed termination after 13 weeks. So if you lay an employee off and you're entitled to lay them off and you don't recall them for a period of time and it exceeds 13 weeks and you haven't been paying the benefits or any other factors, then once that 13 weeks mark is hit, if they're still on layoff after that, they're going to be deemed terminated and you're going to owe termination and severance pay. And at that point in time, you're not going to be, if you've called it a layoff, you're not going to be entitled to dismiss for just cause, because if you're laying someone off, the implication is you're going to eventually bring them back. So the short answer to your question is yes, it is reasonable to agree with an employee, okay, until circumstances change, we're going to put you on this leave. But there needs to be some sort of end goal to it, because if we can't just have you lingering on the books as an employee who doesn't work anymore. And presumably we're going to wait and see what happens with the pandemic. Yeah, maybe that's a good way to do it, and that way you're not paying the employee for not working. But the risk is if you're placing them on a leave, that's not really the function of what leaves are for under the Employment Standards Act. It's been done, and that's actually one of the workarounds that a lot of employers are doing. But you do run the risk of a constructive dismissal claim. And just so you know, constructive dismissal, it's the same as if you fire the employee, right? So constructive dismissal, the result is the same. I'm seeking termination and severance pay because I say I'm constructively dismissed.
So if what I'm hearing, Warren, in that case, unless there's an agreement with the employee, you're probably better to terminate them without cause and just pay the money up front rather than then going through potentially a legal battle, because now they're suing you for constructive dismissal or something else at a later time. You haven't really solved the problem for yourself if you're not really planning to bring them back.
Exactly. And I mean, in terms of making payments, when you're talking small businesses, most small businesses are actually not severance paying employers. To be obligated or be entitled to severance or being obligated to pay severance, you've got to have a payroll of more than 2.5 million. And the employee's got to have more than 5 years of service. So that's what triggers severance. So a lot of larger businesses, an employee with more than 5 years of service at Walmart, they get fired, they're going to be entitled to severance. What you're obligated as a small business to pay or provide is notice of termination. You can give working notice or you can give pay in lieu of notice. And there's minimum amounts under the Employment Standards Act. There's common law rules about paying or providing more than the minimum amounts. But in either case, yeah, you may be liable for that. There are other ways around it too, right? When instead of paying someone termination pay, you can provide them with working notice saying, hey, your job is going to end, in a month, if that's the amount of notice I'm required to give you. And so your last day is going to be, if today's November 3rd, your last day is going to be November 30th kind of thing. And that's working notice for an employee.
Excellent. So the next question is from Joe. How can an employer deal with employees that do not disclose their vaccination status? Can employers compel an employee to disclose? And can they treat them as unvaccinated for the sake of a policy if they don't disclose?
Yes. Yeah. The short answer to that is yes. I mean, it comes up, and the reality is asking someone if they're vaccinated is an infringement of that person's privacy. No question. It's personal medical information about their vaccination status. And so as an employer, you are infringing on that person's privacy when you ask about their vaccination status. The infringement itself is very minimal. It's a small infringement. And the way the law is going is we're acknowledging, yes, that's a privacy infringement, but it's a reasonable one. And any issues with breaching someone's right to retain the privacy over their private medical information is outweighed by the potential need for me to keep my workplace safe. And again, that's going to be subject to the prevalence of COVID-19 and the risk it has to your specific workplace. So if someone works from home, They don't want to be vaccinated. They never interact with anyone at the business. I think the employer might be hard pressed to justify requiring vaccinations of that person and requiring information about their vaccine. But not disclosing their vaccination status, if you're entitled to impose that policy, not disclosing is the same as, yeah, I'm not vaccinated. And the same thing goes for someone seeking a medical exemption. Technically asking for a certificate from a medical practitioner that says this person can't be vaccinated. That's disclosing not only the fact that they're not vaccinated because they can't be, but they also have some sort of medical condition that prevents them from being vaccinated. The doctor's not going to tell you exactly what the condition is, and you're not entitled to know. You can guess, you can infer, but it doesn't really matter. What you do know is that that employee has some sort of medical condition that prevents them from getting the vaccine. But again, this is weighing privacy versus safety. And that debate has happened throughout the pandemic, and the consensus seems to be among lawyers and the courts and the community that's looking at these issues and dealing with them all the time, that the privacy infringement is justified by the necessary safety precautions that we're putting into place. So
I have a question that sort of arises from that whole privacy piece. So if you're a business that is hiring, usually as part of the hiring process, you're not allowed to ask health questions. What is the appropriate way to manage the vaccination policy, if you have one in place, in a hiring process? Do you list it in the job ad? Are you allowed to ask that during the hiring interviews, or does it come down to waiting until the actual job offer?
That's a really good question. I would treat a potential new hire the same way that I would treat an existing employee. And that is, you're absolutely right. Typically, you're not allowed to ask someone personal human rights code-based details, right? Like it would be totally inappropriate to ask an employee, are you pregnant right now? Are you expecting? What's your plan, your family plan in the future? All that it would be inappropriate to ask. In the circumstances here, the medical information, basically what you would tell the potential new hire is, we have a policy in this workplace. You've either got to be vaccinated or you've got to have a valid exemption. Just so you know, when you start, we're going to need that information. And so probably I would put it in the terms of the offer, saying that the offer is conditional on your compliance or your ability to comply with the vaccination policy. And that way, and when you are asking about exemptions, again, you're not asking about specific medical information. You're asking about, are you vaccinated or do you have a valid reason for not being vaccinated? And I'm not a doctor as an employer. I'm not a doctor, so I don't need to pry into what specific medical condition you have. I just need to be satisfied that you have a reason that you can't be vaccinated. So largely what you're doing is treating that employee or the potential hire like an existing employee, saying that a condition of working here is you need to comply with our policy, and then give them the policy. The very small risk, because these cases haven't gone through litigation. I looked some of these up, and there was one last Friday. It was heard in front of Justice Dunphy in Toronto, and that dealt with basically a lawsuit on behalf of both a group of unionized and non-union employees trying to get an injunction to restrain an employer from enforcing its mandatory vaccination policy. That lawsuit was effectively shut down. It was a motion for an injunction, but that basically didn't go anywhere. A lot of these cases, I haven't seen any go through the Human Rights Tribunal yet in the employment context. I think it'll be a long time until it does. I think in the very unlikely event that the advice I just gave somehow breaches the Human Rights Code, that any consequence to an employer for making those good faith inquiries. I'm not asking you because I want to discriminate against you. I'm asking you because I need to implement this policy for the safety of employees. I really see very little risk to employers to taking the approach that I just described.
Excellent. Okay, last call for any questions. If you have a question and you want to just ask it in person, feel free to turn your camera on or unmute yourself. It's going once, going twice. All right. That was really helpful, Warren. Thank you so much for this information. We will be posting the recording of this on our website as well, so that you can go back and review it if you need to. And Warren, how can people get a hold of you if they need to talk to you directly about some challenges in their business?
I would just Google me. Yeah, there are our information. I mean, I can put it back up on the slide here. O Neill Associates, concluding remarks. Yeah, go to our website there, or give us a call, 344-5227. It's 344 labor. I'm not sure how we got that phone number, if it was on purpose or not, but anyways,
Very
I always
creative.
appreciate you having me. It's always a great discussion, and I appreciate those questions too.
Good stuff. Well, thank you all for being here, and have a great rest of the Wednesday and rest of the week, and all the best and stay safe. Take
You
care.
too. Bye now.
Bye-bye.